In today's video, we're answering the question, should I do a blood retest? So when you're stopped and cited for DUI, the police are supposed to take 2 vials of blood out of your body, one for them to test and one that's available for the defendant, in this case, if that may be you, to do your own testing on. You have the right to take that second vial of blood and go get it tested independently, outside of the government's control, outside of their labs. Take it to your own lab and see what the results are. So many times people will ask us, should I go and get an independent test? Should I go and have that vial of blood retested, and how will that help my case or hurt my case? It's really one of those questions that you need to ask your lawyer in Arizona. If you haven't hired a DUI lawyer, you're going to be appointed a public defender. If you can't afford to hire private counsel, they will appoint you a public defender, and you should have this conversation with your attorney, because really there are a lot of questions that go into this. A lot of it's going to depend on the jurisdiction that you're in. It's going to depend on what your initial results look like, what were your blood levels, because this process can help your case or it can hurt your case. It can be a very big problem. Typically, we don't retest samples. We don't go through that process for most DUI cases because the cons sort of outweigh the pros. But here are a couple things to consider. So number one, if you're in a jurisdiction, which means if you're in a court, if you're working with a prosecutor, where they will consider the result of your second test, of your independent second test, they may be worth your while if you're in a jurisdiction where they will consider it, and where it may actually help your case if your blood alcohol content was low. So let's say, for example, that you're at just barely above the legal limit. If you're at a 0.085 or a 0.084, and they're a jurisdiction which may give you a reckless driving or reduce your DUI down to a better type of result if your blood alcohol content comes back a little bit lower. If you're right around that threshold, so say you retest your blood and it comes back at a 0.079, now you're under the legal limit, they may give you a reckless driving on that if your blood results come back different. Same if you're at an extreme level or a super extreme level. So say a super extreme level is anything above a 0.20. If the government's test is above a 0.20, 0.022, and they're not going to, or 0.22, they're not going to reduce it down. If you retest it and it comes back at a 0.199, then that may be worth your while. It may be something where that prosecutor will take a look at it and say, okay, they're right at the border. We're going to drop the super extreme DUI charge and reduce it down to an extreme charge. Now, chances are, if you're at that level anyways, they're probably already offering that plea deal, already agreeing to reduce it down from a super extreme into a regular extreme. Or if you're at the cutoff where you're at that point where they want the super extreme to stick, but if you come back under a certain threshold, they may agree to drop the super extreme. That may be the case as well. So say you're at a 0.216 and you come back at a 0.209, they may say that's close enough to their cutoff that they may drop it down to an extreme. So that's a situation where it can help. Now the problem is, if you go and you get that independent test done, the government can comment on that. So let's say, for example, one of your defenses, which is a common defense in DUI, is that the government doesn't know what they're doing when it comes to testing blood. They're not good at it. They don't follow rigorous scientific standards. Anything that they're doing in the lab is subject to contamination. Their process for actually testing the vials is problematic. They didn't store the evidence correctly. There's a million different ways that you can attack the integrity of the government's blood test. So you want to challenge that. You want to say they screwed it up 20 different ways, and here's where all the problems are. Now, if you go and you take that second vial and you go get it tested, the government can come back, say in the middle of your trial, and they can comment on that. They can say, well, if our test is so bad, why don't we talk about your test? What did your test show? So you took that same sample, the same vial of blood, and you went and got it tested independently. What were the results? If you think our test is so bad, what does your test show? And they can comment on that, which can be very problematic, because now if their test was good and your test is actually confirming those results, say it comes back the same or it comes back even higher, now you lose the argument to the jury that would invalidate their test. So now you can't go take your test, which essentially shows the same as theirs, and make the argument that their process is all garbage, because your process, which was done separately, is essentially validating their results. It's not a good strategy to go in and then bring that back and say, yeah, we think the government's test is garbage, but our test is also showing the same results, so maybe it's not as bad as we had thought. So this is something that it does require a lot of sort of intensive analysis. You need to decide what are the pros, what are the cons. Is it worth getting it retested? There are some additional costs with getting it retested. You have to go and get it processed, and then the results, typically from the experts that we use, you need to get their commentary on it. So it's something that can cost a little bit more out of pocket for a person who's going through this process, and it may not be worth it. However, it may be worth it. This is where you need to rely on your lawyer. If you don't have one, have this conversation with your public defender, see what they want to do with your case. But it is something to consider. It is a tool in our toolbox, and it's important that you know how it works. So if you were somebody that you know or love has been charged with a DUI, if you're going through this process, if you're wondering, why did they draw 2 vials? Do I have access to that second vial? You do. But if we want to use it, that's a whole separate story. That's a separate consideration that we need to have a long conversation about. So give our office a call. We offer free case evaluations. We'll have you come in, we'll sit down, we'll talk about the pros and the cons of actually testing that second vial as they relate to your case. So there's literally nothing to lose. Give us a call. It's a free case evaluation. We look forward to speaking with you soon, and thanks for watching.